Greetings. My name is William Morris. I am a patent attorney. I have been practicing for almost 15 years at this point. And what I want to talk about today is why patent applications get rejected. And what I've done is kind of just put together sort of a list of 5 reasons why your patent application gets rejected. And so what I want to do, go down through those, explain what I mean by these, why they're significant, and then I'd like to talk a little bit about ways just to deal with the reasons why you get rejections and dealing with those rejections. So without further ado, let's get started. Reason number 5 for why your patent application gets rejected is because of 112. Now, why do I say that? Well, if you have any sort of experience with a patent office, that'll sound really kind of weird to you because 112 rejections are not the most common kinds of rejections. Most cases, you don't see a lot of 112 rejections. What you see are rejections under 35 section 102 and 103, so for anticipation or obviousness. But let me show you something to explain what I mean here. So this is a document that I put together. I think this is a good kind of a thing to do, by the way. So over the course of my practice, I have kind of written down sort of knowledge, examples, sort of good practices. And the very first kind of knowledge, example, good practice that I wrote down that I thought was worth capturing was this. It says, behind every 102 and 103 rejection, there is a hidden 112 rejection. So here's where I'm coming from with that. In my career, I have had very few cases where an invention is really the same as the prior art, or where it's really so close it would have been obvious. Probably I could count them on less than one hand. Certainly I could count them on less than 2 hands. But I always get 102, 103 rejections because everybody does. The reason for that is because it's hard. Claims are very hard. So they're hard to write, of course, but they're also hard to understand. So put yourself in an examiner's shoes. They don't know your invention. They get this application. They've got a limited amount of time that they need to review it, to do a prior art search, to match against the claims, and how are they going to do that? Well, it may not be obvious from the face of the claims, especially because claims have to have just that very stilted one-sentence style, right? Where you've got your different clauses, your different elements. And so often examiners will not get the same understanding of what you intended when you were drafting the claims as you had. They won't see it as covering the same subject matter. And so what they'll do is they will reject it based on what they sort of understand it most likely to mean. And because of that, you're not getting a rejection based on the prior art. What you're getting is a rejection based on a miscommunication between you and the examiner. You wrote the claims to say one thing, the examiner interprets them to say another. And if you try and fight that to say, examiner, you're wrong, you don't know, you don't understand, you're misinterpreting these claims, you're going to have a real problem because the examiners, they have the broadest reasonable interpretation rule. And you can see, so number 1 on my little list of intelligence and information to keep in mind is there's a hidden 112 behind every 102, 103. The next is never argue a definition of a word with an examiner. And you can see I've got some of these cases listed to sort of capture this, right? Buszard, that took a split panel of Federal Circuit to decide that the word flexible was not the same as crush. There was a foam insulator, and the claim had a flexible foam insulator, and the examiner said, oh, this is covered by something where the insulator is crushed, right? So therefore it's not rigid, therefore it's flexible. Now, the applicant won that case. But look what they had to do. They had to win it at the Federal Circuit, and it was a split panel. How often is a client going to want to fight that hard to go all that way? The answer is very rarely. And look, one judge, and it would have flipped, and flexible and crushed would have been treated as the same thing. So don't think of this as the examiner is wrong. Don't think of yourself as getting a prior art rejection. The number 5 reason is there is always, it's ambiguity. There's a 112 rejection under it. And so what you need to do to deal with this is to work with the examiner to get your claims in gear. But really, what you have to understand is the number 5 reason that you get your application rejected is, even though they're not the most common rejection, really, it's because of Section 112. It's because of ambiguity. All right, so that's number 5 reason. The number 4 reason why your application gets rejected is ambiguity. So we just talked a little bit about interpreting the claims, but let's look, because that's not the only thing you have to deal with, right? You also have to deal with the law. And when I was starting out, I wouldn't have said this was going to be on a top 5 list because patent law was, it had a lot of very precise rules, right? So in order for something to be obvious, there had to be a teaching, a suggestion, a motivation to modify the prior art in order to get your invention. And that's not true, right? So after KSR versus Teleflex, what you have is it's a much more kind of flexible, it's a much more flexible standard. There's some prior, there's some common sense. So after KSR versus Teleflex, you have a very flexible obviousness standard. It has common sense is one of the things. You don't necessarily have to have a written motivation or suggestion. You have some creativity in one of ordinary skill in the art. The Supreme Court says they're not an automaton. This gives examiners a lot of leeway to reject something as obvious, and it gives them a lot of leeway to come to a different conclusion that you did about a claim that you wrote. You don't write a claim to be obvious, but you write a claim, and the examiner may come to some different conclusion, and therefore it's going to be more likely that you're going to get rejected. And the same, it's not just true with obviousness. So I talk about obviousness because 103 rejection, you see this all the time, but it's true across the board. So in 112, when I was starting, you have the insolubly ambiguous standard for claim interpretation. Now that is not true. You have the Inri Packard case, which basically got rid of that. When I was first starting, you really didn't have to deal with 101. Now 101 rejections are very common, and not only are they very common, they're based on this sort of a lot of undefined terms like what is an abstract idea, right? You will see the word abstract idea all the time in 101 rejections, but that is actually not even a defined term at this point. So there's a lot of ambiguity in the law. There's a lot of leeway for a patent attorney writing an application versus a patent examiner looking at an application to come to different conclusions. And so the number 4 reason why you're going to get rejected is because of this ambiguity, this slippage in the law. So, and that actually leads really well into my number 3rd reason why your patent application gets rejected. So reason number 3 why your patent application gets rejected, acts of God or demigods. God, of course, being the Supreme Court, and demigods being the Federal Circuit. So what I mean by this, essentially, the number 3 reason is really legal changes outside of your control. And this, again, when I was starting patent law, I felt it was seen as being kind of I wouldn't necessarily say boring, but it was reasonably dependable. There had been some changes. There were a lot of changes in the 90s, but things were pretty settled down, I would say. But since I have begun practicing, that's not true. So I mentioned several cases that came out, KSR versus Teleflex, Inri Packard, Alice versus CLS Bank, Bilski versus Capbos is another one that's come out in the time period, Ariad versus Eli Lilly, Williamson's versus Citrix, another big one, so that changed the standard for saying when something is a means plus function limitation. Subsequent cases dealing with Section 101, so there's Vanda, Berkheimer, that changed the standard for applying Section 101. The bottom line is there have been a lot of changes, and every few years there's a case that comes out that will really just shake things up, right? Like KSR killed what had been the obviousness standard for many, many years. When you're drafting an application, you don't necessarily know what the law is when that application is being examined. You send it in, And it may take, several years before an examiner even looks at that. And during that several year period, who knows? Maybe, a fundamental rule like obviousness is going to be completely reworked by the Federal Circuit of the Supreme Court. And so as a result of that, you write it for one set of rules, it changes to another set of rules, you have to deal with that. But that's the number 3 reason that your patent application gets rejected, is because of these changes in legal circumstances that are just entirely outside of your control, but they're unpredictable what's going to happen, but I can predict that they will happen. It is what we would call a known unknown. What is going to happen with these legal changes? And so at the time I'm recording this is 2021. There has just been a new administration sworn in, and that means there's going to be new people at the Patent Office. What are they going to do? The answer is I do not know. I don't know if they'll continue with the current policies. I don't know if they're going to do new policies. I don't know what the changes are going to be. But again, it's a known unknown. I know there will be changes. The things that I draft today, if I just draft them for today, things will be changed tomorrow or down the road or in 2 years when they first start getting examined. And that's a reason why they're going to get rejected. And it's the number 3 reason on this list for why your application gets rejected. Number two reason why your patent application gets rejected is you tried to get broad protection. Now, I'm not saying that's bad, right? That's what I think that's what most people do, right? They try and write claims. They try and write a broad claim saying, this is my invention, I want broad protection. Then they write various dependent claims, narrowing that down, right? And focusing on particular embodiments. So they got very broad claims, and they narrow it down with various dependent claims. But this can, I think, result in rejection, because my experience is there are some cases, and some examiners will really focus a lot on the independent claims. And then the dependent claims, even though technically they're all looked at individually, they almost sort of seem to stand or fall with the independent claims in a case. And let me show you, this doesn't happen all the time, but I want to show you an article I found which I thought was interesting on this subject. So this is an article published in, I think, 2008, so it's a bit old, but it was published by, authored by Justin Patz. You can see he has been a patent examiner, and he still is a patent examiner to the best of my knowledge. And he's an interesting person. He wrote this article, and here's what he says about sort of the independence and the dependent claims. So he's talking about, all right, what do things look like when you are an examiner and, just looking at the practicalities of being a patent examiner. He says, look, searching can be a tedious, seemingly never-ending process, especially if it continues for more than a day or two. In the event that it's unfruitful to find prior art, so maybe you have some dependent claims, it's hard to find the prior art for them. But he says there's still a number of viable avenues for examiners. First, and then he goes through, here's ways you can reject a claim, right? They can reject it using reasoning, case law, precedent, PTO, rules in the MPEP. There are rationales. And then he goes through this list of case law and what kinds of ways you can reject things. And in the end of this paragraph, he says, look, or generally, right? He doesn't say look, but I say look. I say, look, as long as the independent claims have solid prior art against them, which is often the case in light of a broad recitation, an examiner can appropriately use these sometimes less effective techniques, so that's these rationales, case law, etc., to bolster the rejections of the dependent claims and avoid a sectioned office non-final rejection. So what we have here is a description of you can have, because you have this broad recitation, you tried to claim broadly. The fact that you have dependent claims doesn't necessarily get you an allowance. It often does, but it won't necessarily, because you have these sort of secondary things that Examiner Patz is talking about, and the examiner can use these to reject the dependent claims by focusing on the independent claims, getting what they consider to be solid prior art, and using these secondary ideas about things like case law, doctrines, etc. on the dependent claims to reject those as well. So the number 2 reason why your patent application gets rejected is because you tried to claim broadly. There you go. And the number 1 reason why your patent application will get rejected is because you filed a patent application. So let's just talk about the numbers here for a second. When you file a patent application, 85-90% of inventions get rejected. That's just the numbers. Now that doesn't mean that you don't get a patent, right? As everyone who works before the patent office, patent prosecutors know, you go through examination, you discuss, you make your amendments, you make your arguments, but you're going to do that because you get a rejection on the first office action. And so I would say, just again, looking at the numbers, the number one reason why you get rejected is because you file a patent application. And that is the start of the process. And the process goes through, as we've talked about, going through these doctrines, going through how do we get the wording right for that sort of number 5 reason, because, there's differences of interpretation. How do we deal with the leeway given by case law so that the examiner is comfortable, because they don't want to allow or say something should be allowed. There's various quality review boards. They have their supervisor if they're if they're more junior. So they don't want to let something through that's no good. There's a lot of give and take, and that give and take is going to start with a rejection. And so number one reason why you get rejected, because this is the game we're playing. That's just the way it is. But I didn't just go in here to say, look, you are going to get a rejection, and that's it, and all doom and gloom. I do want to talk about some ways to deal with this. So let's start. I'm going to go back to my knowledge, my little knowledge document. I think these are great. Number 4, patents are about technology, not about words. This, again, ties into what I've been saying about, words. There's a lot of ambiguity. There's a lot about sort of changes in the case law. But here's what I think. The patent system, so you have an invention. Your client has an invention. They have figured out a new way to do something, and it makes the world better. And the patent system is supposed to provide incentives for people to do that, and it's supposed to provide those incentives by giving them a patent when they've done that, right? Now, if the patent, given these broad parameters, if the system is working reasonably well, what that means is, regardless of, okay, there's going to be some here back and forth about the words, okay, the law is going to be a little bit, there's a little bit of ambiguity, you should be able to get a patent for that. But you need to make sure that you build in enough so that you can convince an examiner that that's what's actually happened here, right? That it's really an innovation. They really did something new, that it really makes the world better. And so what I would say, my philosophy, one of the strategies I use to create patent applications that I think will be able to deal with these issues, is by really putting in a good deal of detail, more than is legally required, right? Because legally, you write to someone of ordinary skill in the art, you don't have to put in a lot of stuff that somebody of ordinary skill in the art wouldn't need, but I do it anyway. If I have an application for some software and it's got some function, I will walk through that function step by step, even if one of ordinary skill in the art wouldn't need that. Now, of course, the level of detail is going to vary case to case. Where is my real novelty? What's the difference? But I will make sure that when I write this, I want it to have something concrete. I will try and walk through it at whatever level of detail seems to make sense, so that I can explain this to an examiner and make it clear, and then we can work out, now that we know we're on the same page about the invention, what's the language we're going to use for this? How do we craft these claims working together to make sure that it's something they're comfortable with and that it works under whatever the legal rules are at that time, and that it works with language that they think is okay. So that's the first thing I do. The second thing I do is, again, I expect that there's potentially going to be rejections, but it's to know. It's to have the knowledge, have the information, right? So case law changes, but there's some things that are going to be the same. So, for instance, you see this as never argue or worth its examiner, and I've got cases, starting all the way back to 2007, and I could keep going, right? This rule is still in place. Obviousness requires the prior art teach the limitations in the manner claimed. Well, again, I've got cases. This thing, I've got stuff going back to 2008, stuff in 2011. This is still a rule. Have your knowledge. have the information, because you know there's going to be a rejection. So have the information, have the knowledge to respond to that rejection. You can do this a lot of different ways. So one way is you can have this kind of sort of a document that I've done here. If you are working, you have people like your colleagues, right, in a firm, or maybe you have a mailing list. You know, you can talk to people like in your firm or on a mailing list. Another thing that I have done is I've put together software. So I designed patent prosecution software that I refer to as the Arguminer software. And what it does is it goes through file wrappers. All this stuff's publicly available. And it will analyze a rejection. So you will upload your office action. It analyzes it and says, look, here's what other people have done in a similar situation. It might work for you. And you can look and you can filter by examiners. You can filter by keywords to find, the right kinds of arguments or right things that have worked or haven't worked, right? To see what works, what doesn't work, so you can make your strategy. But it's to have that knowledge. So you build your good application. You have all your information in there, but have the knowledge. Have the knowledge of what happens during prosecution so that when you go in, you're not having to reinvent the wheel. You've got this sort of information, and then you can use that working with the examiners to come up with something that they're comfortable with, that you're comfortable with, and that hopefully can get that patent for the thing that, makes the world better. It's new, and you just have to find a way to get there. So that's what I would say. We've got 5 reasons why your application gets rejected and 2 ways of dealing with that. And hopefully with this information, you will be able to do a great job advancing the progress of science and the useful arts and helping yourself and your clients as part of that system. Thanks a lot.